Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us, coming to you obviously from Security Gun Club, but things seem to be really quiet around here. Why is that? I thought there was going to be an injunction today where we're going to stop Washington's magazine ban and we're going to get to live free like Americans again. Yeah, that did happen, all 88 glorious minutes of it before. That's right, your state Supreme Court stepped in and stayed that injunction. So we are back to ground zero once again. Let's get you all up to speed. So today, let's spend a few minutes and let's talk about the shortest injunction in the history of Washington State. Okay, Washington, here's what we're talking about. 51 glorious, incredibly well-written pages by the Honorable Gary B. Buescher from Cowlitz County Superior Court. I am going to go through this order and opinion because I really do have to give it up to His Honor. This is a very, very well-drafted opinion. Of course, we got the word out right away that we had an injunction. All of you went flooding to your local FFLs. I pulled into Security Gun Club to an absolute cavalcade of activity here, only to get a call from Pete Serrano about an hour and a half after the injunction had come out. And we have now found that a Supreme Court commissioner, let me say that again, a Supreme Court commissioner, not actually an elected member of the bench, but a Supreme Court commissioner, Michael Johnson, has already stayed this injunction. Now, if you take a look at the turnaround time from when this order dropped to when the stay was issued, the truth of the matter is, Commissioner Johnson, you know this to be true, you did not read any portion of the court's opinion. There is no way on God's green earth that you read this opinion. Now, as we know, this puts the case squarely back to ground zero. It will now be argued again on the merits before the Washington State Supreme Court. And as I have mentioned on many of the other videos, we might as well go outside and throw rocks at the moon if we want to succeed there. Now, although this ruling is already dead, I do want to go through some portions of it because I think there are some incredibly important and fundamental findings that we need to focus. One of which, of course, deals with what exactly does Article 1, Section 24 of the Washington State Constitution guarantee? Does it guarantee us the same rights as the Second Amendment, or does it guarantee us more? Now, although His Honor did not reach that conclusion, he did make this very important finding. The Washington Supreme Court found that Article 1, Section 24 is absolute outside of its two textual exceptions. The use of the word absolute when describing a constitutional right is unambiguous and powerful. The only condition on the right to bear arms under Article 1, Section 24 are 1. The protected right is one of defense of self or the state, and 2. The prohibition on creating a private militia. Failing to mention other limitations when 2 are specified implies that there are no limitations. Now, as we know, the state of Washington has attempted to argue that the Second Amendment is not even implemented in this issue because, well, magazines standing alone do not constitute arms. His Honor was not particularly persuaded by that argument either. The purpose of a magazine of any size is to facilitate the function of semi-automatic weapons. Magazines, which include large capacity magazines, are designed as critical functional components of the operational mechanism of semi-automatic weapons. Absence of a magazine completely defeats the function of a semi-automatic firearm, even in those guns where a single shell may be fired without the magazine in place. Handguns sold in California, manufactured after 2002, will not fire at all without a magazine in place due to the California requirement for a magazine safety lock. Without a magazine, a semi-automatic firearm is either a single-shot weapon or it functions not at all. Magazines have no other design purpose than as a weapon. No one is going to butter a sandwich or dice carrots with a magazine of any size. Magazines are only useful as weapons. And of course, not only finding that they are lawfully owned, they are lawfully used on an everyday basis for lawful self-defense purposes, as the court found. This court can infer from the record here, as well as the numerous cases reviewed by this court preparing for this decision, that magazines are commonly and lawfully possessed by law-abiding citizens for lawful purposes. The court can also infer from the same sources, as well as common knowledge, that a significant number of modern handguns are designed to hold and are commonly sold with magazines with capacities larger than 10. The state, through the challenge law, has now prohibited the sale and acquisition of such arms. As a critical functional component of semi-automatic weapons, this court finds magazines, including large-capacity magazines, are arms for purposes of Article 1, Section 24. And when we say that they're used lawfully, it's just not by folks like you and me. Consider, for example, Chief Adrian Diaz of the Seattle Police Department, whose declaration ended up in this order. The state's expert witness, Seattle Police Chief Adrian Diaz, posits why his own officers carry large-capacity magazines. Quote, nevertheless, SPD patrol officers routinely carry 17-round magazines because they need to be prepared for every scenario they might encounter. Now, the state tried to argue that the restriction of magazines was perfectly lawful under the state's authority, or what we call police powers. They relied heavily upon a case called Jorgensen. However, unfortunate for the state of Washington, Jorgensen relied on that intermediate scrutiny test, which we now know the Bruin court has completely and soundly rejected. As the court here ruled, the state next argues that firearm rights guaranteed by the Washington Constitution are subjected to reasonable regulation pursuant to the state's police power under Jorgensen. The Jorgensen court applied intermediate scrutiny based on the limited time of loss of the right and a judicial finding of dangerousness of the person. Consequently, Jorgensen has absolutely no bearing or application to the inquiry that we have here today. And as a matter of fact, because the court has found that Article 1, Section 24 of the Washington State Constitution is so absolute in its language that there is no balancing or scrutiny that needs to be engaged in. As the court ruled, the Washington Constitution, Article 1, Section 24, is absolute outside its textual limitations. The application of interest balancing on tiers of scrutiny is prohibited. Now, for all of you who've been geeking out on the channel, you already know what the argument here is. Magazines can't be banned because they are in common use. The only types of items that can be banned per the Second Amendment are items that are considered to be dangerous and unusual. There certainly is nothing unusual about large capacity magazines. Of course, the state tries to point out things like, well, in common use for self-defense or more appropriate for military use. The court makes a very interesting finding, one that I agree with here, which is basically, hey, you know what? The in common use constitutes the historical analysis that we need to use. The in common use principle was developed as the result of the U.S. Supreme Court's historical analysis, not the textual analysis. As in the analysis under Bruin for regulation cases, discussed later, once a court finds that the law implicates the text of the Second Amendment, it becomes the burden of the state to show the banned arm is not commonly and lawfully owned by citizens for self-defense. Now, a couple of other things that I think are really interesting. Number one, what is the relevant historical period? And how does the court deal with the state's argument on, well, you know, this is modern problems and therefore we need a more nuanced approach. We're seeing this new argument ad nauseum. This is how the trial court dealt with it. Given the clear direction from the Supreme Court, this court looks to the time around 1791 when reviewing historical analog laws. If a later law confirms an earlier law as late as 1868 exists, that can be considered. As far as the more nuanced approach that the Attorney General's office argued for here, well, this is how the court dealt with that. The state reads far too much into this comment. First, the language is dicta and not part of the Bruin holding. Second, by its plain language, it is permissive, not mandatory. Third, and most importantly, the comment applies only to the choice of historical analog laws, not the Second Amendment generally, the in common use test or interest balancing. Fourth, before this court could consider laws that are less relevantly similar, the state would need to establish the existence of either a dramatic technological change or an unprecedented societal concern. The comment merely gives an inferior court some latitude in considering historical analog laws in the proper case. And so for all of these following reasons, the Cowlitz County Superior Court came to the conclusion that, pursuant to the reasoning set out in the Washington analysis above, this court finds there are no factual circumstances this court can conceive under which engrossed Senate Substitute Bill 5078 as written and codified could be constitutional under the Washington Constitution, Article 1, Section 24. The court finds ESSB 5078 is facially unconstitutional under the Washington Constitution. Therefore, the court issued an injunction. That injunction lasted all of about 88 minutes before Supreme Court Commissioner, not Judge, Michael Johnson decided he knew better than everybody and stayed that injunction. Listen, we'll go ahead and link up the Cowlitz County order down below so that you can enjoy it for what little time we were able to enjoy it. If you guys got any other questions about this or anything else related to what's left of your Second Amendment rights, you should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down there in the description box as well. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From an incredibly quiet security gun club, thanks for watching and stay safe.